All right, we're going to get started. I want to thank you on behalf of the LRA for coming to Employment Law 101. This is something that we have done for the last few years. It's never been this well attended, but we are awfully happy to have you here today to share with you some information and some things that are of importance. As you know, first of all, I think you guys have met most of our LRA team that is here. Wendy Warren in the back, who coordinated this event for us, and Pam St. Pierre, who's our VP of Member Services, and the rest of our communications team. Steve Carews, our COO, and I'm Stan Harris. I'm the CEO of the Restaurant Association. I call myself a recovering restaurateur. I got to spend 30 years in the business. I'm on my 12th step. I'm going to get a coin soon. But of late, when I got out of the business, I always said I wanted to have two things: no inventory and no employees. Well, I'm halfway there. But our industry of late has been under attack. There's no question about it. And it's been under attack for the way it engages with its employees. The media inquires regularly to us, what's the LRA doing? Thinking that we're some sort of regulator, not realizing that we're the advocate for the industry. And we always give the same comment. It says that we encourage all of our LRA members to be compliant with any law or regulation as it relates to employment discrimination or harassment. Now, that's never been in the media because that's just not the kind of meat that the media is looking for. Today, we put this gathering together to just share some information in three areas. First, we'll welcome our LRA employment law firm, Fisher Phillips, ably represented by two partners, Michelle Anderson and Steve Cupp. Both of them have presented with us before. And one thing that we will share with you as an aside that I know Michelle will cover, but in the event that you need an employee handbook drafted or something reviewed, they have a very good structured fee structure to be able to take care of that and assist you as an LRA member. So it's something that you certainly want to avail yourself of. They help us with ours, and I didn't know there was bone marrow leave in Louisiana for under 20 employees, so that kind of shocked me. We also welcome Postlethwaite Netterville. In addition to being a large CPA and tax firm, as they said, the needed CPA and the dreaded tax guy, they also provide HR and other consulting services, audits, consulting, and third-party resources. We're pleased to have Helene Wall, who's somewhere back here, that is going to present today, and she'll walk you through some ideas about what you should be looking for in your third-party provider or what you should be doing to protect your business. And finally, John O'Brien with Arthur J. Gallagher and Company. He's the Area Director of Hospitality and Program Insurance. John's one of my go-to guys when we need to talk about interesting risk situations, and he'll review specific insurance coverage and practices that you might want to consider. There'll be ample time for questions and answers, and as you note, we're shooting video of this, so if you'd like to share it with some of your colleagues that aren't able to attend today, it'll be on the LRA website at some point before too long. We do ask that if you're in the room, you silence your mobile device. If you need to step out and take a call or make a call, just step out of the room so we won't disrupt what's going on. And then just to share with you a little bit about how we look at the job that you give to us as the Restaurant Association and looking out for your interest and advocating on your behalf. We really do believe that restaurants are the fiber and part of the fabric of America. And whether you walk through the doors for a first date or a first job or a family meal or celebration, it all comes back into this experiential piece. You, as employers, provide fundamental skills and values that help people pave a positive path for their future. And it's our people, not just profits or assets, that are our most important element in what we do. And they're our greatest asset. But we've got to get people that want to talk about personal responsibility, hard work, being disciplined, and having integrity. It's what our employees want and value, and it's certainly what you value, and it's what they deserve. So what we hope today that we help you provide a better understanding of your responsibilities as an employer and to have an engaged workforce in the hospitality workplace. So without further ado, we turn it over to Michelle and Steve and welcome you. Thank you.
Okay, well, we're so happy that you're here today. For those of you who I have not met before, I'm Michelle Anderson. I'm a partner with Fisher Phillips. I work here in our New Orleans office, but I also practice in our Tampa office as well. Some of you may have talked to me over the phone or even by email over the last several years. As you may know, part of your membership to the Restaurant Association gets you access to us. If you have some quick, simple questions, you're not sure how to do a tip credit, tip pool, you've got a question about overtime, you've got a difficult employee, we handle all kinds of questions from you guys all the time, and that's part of your membership, and we're happy to do that and really enjoy this relationship that we have. Again, Steve is with us, and he is from our Gulfport, Mississippi office, but also practices here in Louisiana. And he will be chiming in. We've sort of divided this, and I'm going to take the harassment discrimination side, and that he is going to talk more about the ADA, FMLA, pregnancy discrimination aspects, which will happen after the break. Because we have about 50 minutes and a lot to cover, normally the stuff that Steve and I are going to talk about is almost a full day of training. So I'm going to say lace up your shoelaces and hang on tight, because we're going to go quickly. There will be time for questions at the end, and this presentation will be made available to you, so don't feel like you need to sit there and jot a bunch of notes or take screenshots. I really just want you to listen and process the information, and if you have a question toward the end, then we will get to those. Just a little bit of background about me. I have not always been a lawyer, and actually probably don't like lawyers for maybe the same reasons that you don't like lawyers. But my background was in workforce development, so I was on the management side, and I used to put people to work. I also am a former bartender, so I have worked in your industry as well. Several years ago, I decided that I wanted to go do employment law, and this is all I have done for over 10 years. So I bring to you my practical experience from the HR and the workforce development world, couple that with the legal experience of working with businesses solely to help try to get you in compliance and keep you out of hot water. Oftentimes I joke that if I work my way out of a litigation job, I'm okay with that, because that means that employers are taking the time and they're investing in themselves and their businesses and their employees to make sure that they don't become the next headline. And ironically, I have started to work my way out of a litigation job because people are calling me before they make that termination decision. They're calling me when they get that harassment claim, and we're working through an investigation to try and limit your risks. So, with all of that background, let's talk about trying to keep out of the employment discrimination and harassment news lines. So we're here to reinforce the zero tolerance. You should have a policy in place if you have, I would say if you have any employees at all, even if you are not technically covered by the law because you don't even have 15 employees yet, I think that it's still a good idea to have a policy in place. So we want to reinforce that message. Part of what today is about is I think we have to start reframing the culture of the hospitality industry. I recognize, having worked in it myself, many of us were very young when we started out. It was our very first job. A lot of us didn't know what it meant to be professional. And people who continue on in that industry over the years, a lot of times the things that we learn, whether they're good or bad, but sometimes bad habits continue to replicate themselves over time. And so we don't ever improve upon the culture of making sure that people are treating each other with respect, that we're doing things the right way, that we're being respectful. And over time, what has happened is the culture has become, I think, problematic, where a lot of things are going on that we know shouldn't be going on, but we don't know what to do to make it better. So hopefully today we will help you find ways to supervise and train and have a good, productive workforce to make sure that these issues of harassment and discrimination are not occurring in your workplace. Because quite frankly, if you have ever been through any kind of litigation, whether it's a harassment or discrimination claim, or even something, a workers' comp claim, you know how time-consuming and expensive those are. You know how stressful that is, and you know how much of a distraction it is from your business when you're trying to fight a lawsuit. So we want to try and keep that from happening. Of course, you should care because it's the right thing to do. Right? We don't want people to come to work. I always say this because plaintiffs' lawyers always say, oh, well, employers are so bad, and they hire these employees and they don't want to pay them right, and they want to treat them well and kick them out on the curb. I said, think about that statement. Does it really make sense that I'm going to spend all of my time trying to find the right person, to make that job match, to bring them on, only to treat them poorly and to not pay them and then put them back on the street? Turnover is time-consuming and expensive, and the more turnover you have, the less business that is getting done. So the right thing to do is to obviously have a good, productive working environment. Of course, there's the numbers aspect. There's personal liability involved with many of these claims. Even if The company is considered the employer for purposes of a discrimination statute. There are all kinds of state laws that will allow an employee or even an applicant or a customer to sue you personally for some other kind of tort. It can result in people losing their jobs. It can result in people losing their businesses. The financial costs, particularly if you don't have an insurance policy to help cover some of those costs, can be exorbitant. And then, of course, I think we all know that unhappy employees are unproductive employees. At one point, I read a study that says it takes 21 positive comments to counteract one negative. So think about how much negative stuff we hear during the day on the news from our friends, our family, other sources, and think about how many do we really hear the 21 positive comments to counteract that one negative. So if you've got someone in your work environment who is harassing your employees, whether it's a customer, a manager, an owner, another employee, a vendor, are they really getting those 21 positive things to counteract that one negative each day? Probably not. Lots of laws. We could spend days talking about all of these laws. It would bore you to tears. But some of the ones that you need to be aware of that you're covered by are listed here on the screen. The main ones that we're going to be talking about today are the federal discrimination law, which is Title VII. We've got the Age Discrimination Law, the Americans with Disabilities Act, the Pregnancy Discrimination Act, and the Equal Pay Act. Those are the main ones that will be sort of in the background of our conversation today. Louisiana also has its own employment discrimination law as well. Covers many of the same classes, but has some different remedies to it and some different prerequisites before you bring a lawsuit. So who is covered by the discrimination laws? Everybody is. Applicants, employees, your managers, your vendors, your customers, your clients, everybody is covered. So even if the person doesn't work for you, if they are a third party and they come into your business and are harassing your employees, your staff, you could still be responsible for preventing a workplace that is free from harassment and discrimination. And I know, having worked in a bar myself years ago, it was not uncommon to get hit on by customers. It would happen, particularly the more that the drinks, and I could make a really good drink. And sometimes they just didn't realize that their inhibitions were going down, so my tip would go up. We know how it works. But it's at time, as the employer, unfortunately, once we become aware that there is a situation, it is our duty to step in, to investigate, and remediate the conduct. So protected categories, again, these are a lot of categories, but a lot of what we're looking at today, of course, will be the sex and the gender, which has been one of the most prevalent issues that we're seeing in the news. But as I'll show you in a minute, actually not the most prevalent claims being made. Age, over 40, race, national origin, religion, disability, pregnancy, and then of course we have a slew of other federally and state protected categories as well.
Michelle, can I mention something?
You bet.
When I was going to school and going through taking classes in law school, we were always taught that sex discrimination meant a protection of females in the workplace. Race discrimination meant protection of minorities and African Americans in the workplace. That's not what it is these days. The law says that you're protected on the basis of race and sex, and that means both men, women, Caucasians, African Americans, and all ethnicities are protected in the workplace.
Right. Exactly. So the EEOC is the Federal Equal Opportunity Employment Commission. And some of you may be very familiar with the EEOC for a variety of reasons, but this is the federal agency that has been tasked with the enforcement efforts for several of those laws that I just mentioned: Title VII, age discrimination, disability discrimination, pregnancy, Equal Pay Act, and the Genetic Information Non-Disclosure Act. We don't see that a whole heck of a lot, so I'm not going to talk about that today. But they most recently released their statistics of charges filed for fiscal year 2017. So there were over 84,000 charges filed around the country. That is actually down about 6,500 charges from the previous year. Retaliation claims are now, for the 8th year in a row, the highest percentage of claims filed, nearly 42,000. And what retaliation means is I complained about something. I engaged in protected activity. I said I was being harassed. I said I was being discriminated against. And then you did something bad to me. You fired me, you demoted me, you docked my pay, you switched my shift, you did something bad to me. The reality is, and Steve and I both find this because we do EEOC charges and the litigation that comes afterward, oftentimes the person did not complain and they really don't understand what retaliation means. But we've also seen where the person has complained and the company didn't take it as seriously as they should have. And there were maybe some other performance issues going on with this person, because I have seen this, ooh, I've gotten written up for the third time, ooh, I was harassed. And so now we've got someone who is complaining now that they're in trouble, now they're trying to get someone in trouble. And the company doesn't want to take that seriously because they think that the employee is saying this just to kind of get a pound of flesh out of the company. The reality is that even if we think that's the case, it is still our duty as the employer to investigate that claim and determine if there's validity to it and to remediate the conduct. Now, that does not mean the person is bulletproof, that if they are breaking your rules and they're doing things they shouldn't be, that they can't be disciplined, but we just have to be very careful about how we handle those discussions.
Yeah, and I do want to mention that you may look at the percentages and that adds up to more than 100%. Anybody who's seen an EEOC charge knows that you can check multiple boxes on it. So there may be a age, sex, disability, and a retaliation box marked.
I call them the kitchen sink cases.
Yeah.
I've had people, I had one several years ago, the gal checked every box, but she was like 19, and so age didn't apply, and she was white. Anyway, so you just never know. But Steve is right. You can check more than one box, and so we do typically see, an underlying claim such as sex or gender discrimination, and then the retaliation checked as well. The EEOC does also file lawsuits, and I will tell you that I've litigated against the EEOC and won. And it costs my client a lot of money, because when you litigate against the EEOC, it's like litigating against somebody with a blank checkbook. So being sued by the EEOC is not a lot of fun. But last year they brought 184 lawsuits. Between all the various arms of the EEOC that does recovery, so that would be their litigation arm, their mediation arm, their conciliation, they have various processes, but they recovered $484 million for the claimants in the last fiscal year. That's a lot of money. So Steve kind of already touched on this, but unlawful discrimination is treating an employee or an applicant differently because of their protected category. So to piggyback on what Steve said, everybody's protected. You know, the way these laws started was it was to protect African Americans and other minorities. In fact, they threw women into the bill thinking that no one would want women to have equal rights, so we hope that it tanks the bill. Well, it didn't tank the bill, and the Civil Rights Act passed in 1964. And then you would hear these things such as reverse discrimination. Well, white men aren't covered. Everybody is covered. It doesn't matter what your race is, what your gender is. If we are making a decision about you because of those things, then we might have a problem with discrimination. So think about it broadly when you think about what could be discrimination. Variety of examples. It could be a difference in pay, where we are performing the same work, but we're not being paid equally when you look at apples to apples. Part of the problem with the equal pay movement has been we're not always comparing apples to apples, but there are some studies out there showing that when you do compare apples to apples, that there can be some disparities. Failure to hire. And this could be for a variety, on a variety of fronts. I'll give you an example. I had an individual was hard of hearing and was applying for a helicopter mechanic job. Well, guess what? Being able to hear is not an essential function of the job. But the person assumed that we didn't hire them because they were deaf. Well, there were 250 applicants for one job. We hired the most qualified person. But the individual filed an EEOC charge claiming that we failed to hire them because they were hard of hearing. Of course, the EEOC found in our favor that no, number one, we could prove that through all the applicants, we picked the most qualified one. And secondly, being able to hear was not an essential function of the job. And third, we actually had a helicopter mechanic who was deaf that already worked for us. But again, the problem is that applicants don't often know why we don't pick them, right? Because most employers don't tell them why they weren't hired. So if you have somebody who's out there thinking, well, all these employers keep rejecting me, it must be because of my race, or I showed up in a hijab, so it must be because of my religion, at some point, businesses start to draw these failure to hire claims. So you could get sued by an applicant. Failure to promote. I had a slew of these for a company several years back, where the progression within the company was not clear, how you could apply for internal openings to be promoted, or how you could get additional training so when those openings became available you would apply. And so the appearance was that a particular race and gender was getting the opportunity to get promoted and others weren't because they weren't in on the process. So again, those things need a level of transparency, because when they're ambiguous and you start looking from the outside in, it might appear that one class of people are getting passed over for another.
Keep in mind that any notes you take during the hiring process or promotional process may be discoverable in litigation.
Absolutely, and never write on their job applications. Never, never, never write on their job applications. Okay, more examples. Differences in job assignments, giving people better shifts or worse shifts, depending on which the case may be. You might be denying one person overtime and giving more to another, or more overburdening one group of people with overtime versus another, giving one group of people the dirty work and not the other, or the training opportunities. Differences in respect, how one group of employees are talked to versus how another group of employees are talked to, by differences of tone or respect, a different name calling, things of that nature that can be a problem. But the bottom line is if we are treating employees differently under similar circumstances, that's really going to start calling your judgment into question if it looks like we're treating one group of employees one way who fail to come to work repeatedly, and we give them umpteen chances before we write them up and fire them. And then we have another group of employees over here of a different protected class, and the first time they fail to show up to work or call in, we fire them. So we have to look at, when you have these disciplinary situations, have we had this situation before? Are the facts the same? Are these people in the same job? Are they doing the same kind of thing? How did we handle that situation before? If we're going to handle it differently this time, is there a reason we're going to handle it differently this time? I always say the facts make the law walk and talk. So sometimes we have some extra facts that maybe we didn't have before. But oftentimes we're going so fast, things are moving so quickly that we don't stop and pull back that institutional memory to think, what did we do before when this situation arose? And then all of a sudden we might find that, and it wasn't intentional. You're not intentionally taking one race or gender of people and treating them differently than another, but we might not really be looking at the whole picture about what we've done in the past, and it could be a hidden bias for all that we know. So you've got to think those things through.
One of the things that's important there is the different treatment based on a protected characteristic. And I think,
Right.
Michelle, if you have a probationary guideline that says someone's on probation for 90 days of their employment, and they're frequently, and they miss 2 or 3 days in the first week or first 2 weeks, but you allow someone that's been with you for 5 or 6 years to have a little bit more leeway with discipline, that's not based on a protected characteristic, because one's a probationary employee and one's not. Now, it could look bad if all the ones that you are disciplining are African American and all the ones you're not disciplining are Caucasian. That could call into it. Right. But it has to be a protected characteristic. I think that's an important
and that's why I
point.
say you need to look at the situations when they're presented to you. When you have a disciplinary situation, you kind of need to look at the global perspective and say, what has happened before? How did we handle this? Did we treat someone differently? Would there be even the appearance that we're treating someone differently because of, because they're pregnant or because they have a disability? Why are we doing things differently this time? Obviously, termination is a very common claim that we see in discrimination cases, sometimes because they'll say, oh, we're an at-will employment state, I don't have to tell people why I'm firing them. Technically, you don't have to, but the problem is when people are surprised that they're being terminated and you don't tell them why they're being terminated, guess where they're going to go? They're going to go to the EEOC, they're going to go to the Louisiana Workforce Commission, they're going to go to the Labor Board, the Department of Labor, and a plaintiff's lawyer. They're going to go find out why they were fired. So, and oftentimes what they'll say is, well, that's not the real reason. The real reason you fired me is because of my race. The real reason you fired me is because I'm pregnant or because I have a disability or I need to go on leave, not because I stole from you and then I quit coming to work. Again, sometimes we have to say, really, you wonder why you were fired? And sometimes they really just don't understand why they were fired.
We recommend that you always be truthful to the person.
Yes.
Don't make up a false reason. If you have trouble getting the language together, call us and we'll help you. But it's much easier to defend the truth.
And one problem we see oftentimes is on the unemployment claim, because a lot of times employers don't want to fight the unemployment, and so they tell the employee one reason why they were fired, and they think they're helping them by filling out the unemployment paperwork differently so they won't lose their benefits. Let me tell you how many times that's backfired and called into question why an employer really fired the person when you've got an EEOC charge going on at the same time. So you're not doing yourself any favors by filling out one set of paperwork one way, telling an employee something else. If you really don't want to fight the unemployment claim, you don't give very much information, quite frankly.
Or don't even turn in it.
Because here you're supposed to turn it in within 72 hours, but quite frankly, they're not going to take away your birthday if you don't. So you can always wait for them to reach out to you to give the information, and then you can either not respond, or, for example, I had one recently where the person walked out, and there's a little bit more drama attenuated with it, but we could just say, quit, and not say anything else. That person will probably get denied the first time out for benefits. They'll appeal within 15 days. And what I tell employers is, if you really don't want to challenge it, when they call for that phone hearing at 9 a.m. on a Thursday morning, you're out having a cup of coffee. Like, you're just not there to participate. Because at the end of the day, getting someone disqualified from unemployment benefits is very difficult, and it's usually not going to be worth your time. And there can be a lot of damaging things that come out in those unemployment appeal hearings, because they are sworn under oath before an administrative law judge. And it's not uncommon for an employee to get a lawyer to jump on those calls and start questioning you under oath, and you don't have counsel. So you got to really think these things through when you're filling out your paperwork. Sorry, on a tangent, but these are these things that just come out as I'm thinking about them. All right, harassment. We've heard a lot about that lately. Who can be sued? The company, obviously. These statutes define employer as the company, but sometimes some of these statutes are actually broader and can also encompass the management and the supervisor. But there also can be individual tort liability under state laws for managers and supervisors. So we're talking assault, battery, intentional infliction of emotional distress, defamation.
Tortious interference with employment.
Tortious interference with employment. There's all kinds of things that you personally could be sued. Other employees could be sued, the owners could be sued. There's also a federal race-based statute where anybody could be sued, whereas Title VII would limit race discrimination claims under that to the company. There's a claim that's called 42 USC 1981, and you could be sued as an individual for interfering with a racial minority's ability to contract as an individual. So I have seen business owners and managers sued under that statute as well in race discrimination cases. So harassment covers not just sex harassment, but sexual harassment and other kinds of unlawful harassment based on the protected categories that we looked at earlier. So sex harassment is a form of sex discrimination, and it's because of the person's gender. So because you're male, because you're female. So it can be same sex. Again, where these things originated from was it was meant to protect women, but the law evolves over time. And as I said, the facts make the law walk and talk. So over time, courts have looked at cases saying, oh, well, actually, that would fall within the umbrella of sex discrimination. So for example, sexual orientation and gender identity are not covered under federal law. However, there are cases where they're called gender norming cases, where a female employee was not meeting the feminine standards of the employer's workplace, and she sued on the basis that she was being discriminated against because of sex. And they said, yes, if you are treating someone differently because they are not conforming to gender norms, then you are discriminating against somebody based on sex. So.
Yeah, and there are cases working themselves up to the circuit courts dealing with sexual orientation discrimination, and we predict probably not this term, probably the next term, the Supreme Court's going to decide that.
Yeah, they may take that on. But what has happened is many states have gone ahead and covered those protected categories anyway. And so, and some businesses have just said, you know what, a lot of people that work in our industry happen to be, gay or lesbian, bisexual, transgendered, and we just really don't care, and we don't want that to be an issue in our workplace. So some businesses have just gone ahead and added that into their EEO classifications, even though by law they wouldn't have to, because at the end of the day, we want people to come to work and feel comfortable about being there and be productive and make us money, right? Because if they're not there, if they're there and being unproductive, or they're suing us all the time, well, we're not making money. So
I would recommend definitely include LGBT protections in your policy.
right.
That's
yeah.
bottom line.
I do it all the time. I do 50 state handbooks all the time. I have clients that I update them twice a year, because if they're in California, the laws change like every time you blink your eyes. So, but a lot of them, again, have just done that because they're like, it's just something we really don't care to make an issue in the workplace. Let's just be all inclusive and recognize that this is the way it is, and let's focus on the positive aspects of the business. All right, sexual harassment, there's two different kinds. You've got the quid pro quo, or the this for that, and then you've got a hostile working environment. So quid pro quo is reserved typically to those who would have the ability to affect someone's terms and conditions of employment. So a manager, a business owner, a co-owner, supervisor, someone that could actually take action on that. So this is unwelcome sexual advances, requests for favors, basically saying if you sleep with me, I will hire you, I'll promote you, or I won't fire you, whatever the case may be. But basically the person who is propositioning that employee or that potential employee has the ability to make it happen. And so that would be the this for that. You do something for me, I will do something for you, or I will not do something for you.
And these are not that common anymore.
Well, they probably are not as common, but we see this come up in issues where managers are dating subordinates. And this is what I always say. Look, I know we spend a lot of time at the workplace, and there are people who have met the love of their life at work. I have worked with married couples for years, and you wouldn't even know it because they're so professional. It does happen. However, most of us have exes for a reason, right? They are our exes and will remain our exes. And most relationships end, and most relationships end badly. And so before you decide you're going to date somebody in the workplace, you really need to think it through. And before you as a manager would do that, you probably want to say, no, I shouldn't, because the reality is you're going to probably try and keep that relationship a secret, right? Because you don't want everyone else to know. And as soon as someone gets their feelings hurt and there's a breakup, it's going to be, ooh, she made me sleep with her because she said I would get the best shifts if I did, or I would get more money, or I'd get promoted. You know how that's going to end. So don't date your subordinates, and don't let your managers date the subordinates. And I don't even like managers dating managers, but at least when that happens, at least we might be on some equal footing. But I also say if there's going to be a relationship in the workplace, it needs to be disclosed to, if you have an HR department, it should be disclosed, or if you don't have an HR department, then to the business owner, manager, because there needs to be a determination made about whether or not this is appropriate. And there might need to be a love contract in place. And a love contract is where we say we have entered into this relationship consensually. We recognize that the employer has a non-harassment, non-discrimination policy, and that this relationship, should it go south, we are not going to claim that we were harassed and discriminated against or forced into this relationship. And we're also not going to let our drama when the relationship falls apart play out in the workplace. And we're also not going to canoodle in the corner and text love emojis to each other on our breaks. So,
like a B-52 song.
That's right. We are not going to be the love shack. Yeah, sample,
yeah.
yes.
Yeah.
Yes. All right, yes, a love contract.
That's what it's called.
Okay, so a hostile working environment can be anybody. It could be a supervisor who is permeating an offensive, unwelcome, severe or pervasive conduct, sexual conduct in the workplace that a reasonable person would find intolerable. But it could be coworkers. It could be you've got, you know, the guy that thinks he is like, you know, the hottest thing ever since sliced bread, and he's like hitting on all the ladies. Or you could have a customer that thinks that he or she is quite the Casanova and they're always hitting on your people. Or it could be a vendor, a supplier. But somebody in your work environment, whether they're a third party or someone that works for you or you yourselves, you shouldn't be doing this either, is engaging in some conduct that severe could be one time is enough. So one time, like exposing yourself, rape and assault, anything.
Really any touching.
Any,
These days.
Harmful, touching. Not like I'm patting you on the shoulder, oh, you've had a bad day. Not like that, but egregious touching. Or pervasive, which means when you look at the course of time that these things have occurred, it's pervasive that the workplace is permeated with sexual whatever, tension and harassment because of this person or this group of people. So a supervisor could be a part of that, but it could be coworkers doing it to each other, it could be customers, it could be vendors, it could be anyone. So sexual harassment can be the unwanted sexual advances versus asking out on a date. Again, don't like a lot of dating in the workplace, but it's going to happen. If you ask them out once and they say, no, I'm not interested, then you need to stop asking them out. Because if you continue to ask them out and say, oh, you might change your mind, I really am a nice person to hang out with, at some point you're crossing the line into potentially harassing them. So being flirtatious, propositioning, asking for sexual favors, suggesting some kind of bad thing will happen to them if they don't take you up on it, gestures, displaying suggestive pictures, emails, things in the workplace. I have had that happen where someone has something up on their cell phone screen or on their computer screen, and it really shouldn't be there because it would not be in line with having a harassment, discrimination-free workplace, and somebody who they didn't intend to see it sees it. And so now we've got a problem because they saw something that they shouldn't have. Now, does that mean that you're going to be sued for millions and millions of dollars and lose because you had one inappropriate picture on the computer? Probably not. But what you do with that, once you find out about it, is going to be the issue, and we'll get to that in a minute. So talking about sex and sexuality, it's common, particularly, again, we've got a lot of young folks in our workforce. We have a lot of people who have never worked anywhere else. We have people working late nights and weekends, and a lot of times there's sort of an after culture that goes with the industry too, where people are going out at night and they're hanging out. And so they talk about their dates and their sexual experiences and all of these things while the business is slow for the day. And at some point, that can become a problem. I mentioned exposing oneself. I will tell you, probably every year to 2 years, we get a call about someone exposing themselves in the workplace. I'm sorry to say it's always a man. Not trying to pick on you. I'm fairly certain that if a woman had exposed herself in the workplace, no man has ever complained about it. But it could very well happen. But I will tell you the only cause finding I have ever had from the EEOC was on an exposure case, and here's what happened. So we had, it was an auto dealership, and we had a cashier, a young gal in the cashier's booth. And there was a mechanic who was good 20 plus years older than her, was hitting on her, asking her out, saying some inappropriate things. She goes to some very low-level lead, not even in my mind someone who's truly a manager, but because that position was not well defined and he had the name manager in his title, it was good enough for the EEOC to call this person a manager. She went and she said, hey, I just want you to know so-and-so is hitting on me and asking me out and saying some things. I don't want to get him in trouble and I don't want to make a big deal out of it, but I just want you to know it's happening. Okay, so what little manager should have done is said, thank you very much for telling me that. I do have to tell Human Resources because now that you've complained to me, I have a duty to take it forward. I understand you don't want to get him in trouble. We're going to handle this real responsibly and as confidentially as we can, but I can't keep it quiet. Thank you for coming to me. What do you think he did? Nothing. Nothing. He does nothing about it. So fast forward 6-8 months later, and this team lead guy is even gone at this point. And now this technician exposes himself to the woman in the workplace. Well, of course, HR's on it like that. The manager's on it. They call the police. They have the guy arrested. They participate in his trial to get him convicted. They, take care of her, whatever needs to be done, and then she sues them for discrimination. And the EEOC said, yep, you screwed up, because you had this low-level manager that when he was told at the earlier point in time that we could have gotten in there, we could have investigated and remediated the conduct, and you didn't do anything about it, and that little manager who didn't even work for us anymore made us liable. So that's the scary reality that you need to take back to your supervisors. When I train supervisors, and Steve and I do this all the time, I do supervisor training a lot, and I always tell supervisors, you are the company brain. Anything that you do as a supervisor, if you break the law, if you harass somebody, you discriminate against somebody, it's as good as if the owner did it themselves, because it's strict liability. It goes straight up to the top. So
a supervisor is not an employee, and a lot of them don't realize that.
Right. They don't understand. And again, most of our supervisors, and in my background too, I worked my way up through the ranks. So I got promoted because I did a good job, right? I was very fortunate that the nonprofit I worked for, when I got into management at a very young age, they actually had me trained properly as a manager, as a supervisor, how to deal with employees. But I will tell you, most businesses don't have the time or the resources to invest that kind of money into the people that they promote from within. So how do we learn our supervisory skills? We learn our supervisory skills from the people that supervised us before, right? And sometimes we learn from those supervisors, well, these are things I don't want to do. Like, I don't want to be a jerk to my employees, but we might not realize there are some other things that we're doing as supervisors that we still shouldn't be doing. So things that we need to be aware of. Again, shouldn't be touching folks at work, but there are times when it might be appropriate. There's been a death in the family. There's a sick family member. They find out they have cancer. I had someone today that had recently had a pet die, and they're just completely distraught. And first day back to work, and I said, "Are you okay? Can I give you a hug?" And she's like, "Yes, I could really use a hug right now." It's not sexual harassment, but it was me being a compassionate human being. So
I'm not compassionate. I have to know you 20 years before I give you a hug. Especially the people in the workplace.
So again, you've got to use some common sense. But when these things, the touching, the hugging, the kissing, I call it the hot boxing, when you could easily get by them, but you try and brush up against them anyway. Those kinds of things, and I've had some charges where a gal said, he brushed by me when I was at the photocopier. Okay, first of all, there's this much room between you and the wall and the photocopier. I'm fairly certain he wasn't trying to brush by you. I'm like, did he grope you? Did he? No, he just brushed by me. Okay, well, that's not going to be sexual harassment, but maybe we tell him to ask you to step out of the way next time. So things like that. But when it starts to become excessive, pervasive, we might have a problem. Harassment based on any other categories, it's the same idea. The only difference is there's no quid pro quo when you're talking about race, age, disability. You're only talking about the hostile working environment standard. So again, it's severe or pervasive, unwelcome conduct that rises to the level of permeating the workforce, and a reasonable person would find it unreasonable. So other harassment could be certainly racial slurs, epithets, jokes where you're making fun of a particular race or gender. I get this question all the time, what about the N-word? My rule is no one uses it. No one uses it in the workplace. I don't care what your background is. I don't care what color you are. I don't care if you feel that you're entitled to use that word. Nobody uses that word in the workplace. Let's just make it that simple. And then we don't have to worry about someone taking it the wrong way, saying it the wrong way, someone being offended. We just don't use that word. But being vulgar, telling jokes, name calling, being abusive, sending text messages and emails. My rule is you don't text with your subordinates. I don't like text messaging with subordinates. First of all, I can't keep track of those. I can keep track of an email. I can probably even keep track of a voicemail, but let's face it, we change our phones a lot. Our phones get broken, they get lost, they get stolen, and your text messages, other than pulling your phone records that I can see a text message occurred on a date and time to a phone number from a phone number, I can't see the substance of those text messages. And so if you are texting with subordinates, or your managers are texting with subordinates, it becomes open to interpretation about what that stuff was in the text, right? That the text may or may not be there anymore. So that
But
can
if it
be,
is there, it's discoverable.
of course, if it is there, it's discoverable, but you have to realize too that the life of a charge of discrimination is long. So right now the EEOC is so backed up that I have charges that have been pending between 2 and 3 years. I have one that's been sitting for 6 years. That is how long these things will sit. Well, what happens in that period of time? Evidence disappears, employees turn over, our memories fade, all these things happen. Certainly our text messages from 5 or 6 years ago are probably not going to be around. So if you do have text messages, I always say download them, print them, put them in the file if you do have them. But I think one of the easiest ways is to not be texting with your subordinates because again, it could be a problem. So we've got to be careful about mocking, using stereotypes, that's a whole nother thing. And again, a lot of times people don't realize it and they'll say, oh, well, I didn't mean it that way. Or they start the joke with, don't be offended, but have you heard? If you're going to start something with, I don't, or my favorite, I'm not a racist, but. If you have to qualify what you're about to say with, I'm not a racist, I'm not a homophobe, I'm not a sexist, if you have to...
I probably shouldn't say this.
Or I probably shouldn't say this, or then that should be the end of it. You probably shouldn't.
Oh, we got some.
There's our sound.
Oh, and we got a new guy. I don't know if he knows how to do anything, so don't ask him to do anything complicated.
You're an idiot, aren't you? Come on, figure it out. You are the absolute worst.
So we get a lot of questions about bullying, and is bullying harassment? Sometimes bullying can be illegal harassment. It can be based on someone's category, and sometimes you just have an equal opportunity jerk. Now, the equal opportunity jerk is as big of a problem as the person who is actually harassing or discriminating against your employees, because they are creating negativity in the workplace and they're still creating liability. Because how do we discern where you're a jerk about this because of my race or my gender, or you're just a jerk? And I will tell you, I had 14 lawsuits about 3 years ago with the equal opportunity jerk defense. And you have to go before a jury hoping that they do not like the plaintiff more than they don't like your client, because you can't deny things were said or things were done. You just basically have to take the position that, well, but they do it to everybody. It's not because of their race or their gender, their religion, or because they were pregnant. That's just how this person was. And I always tell my clients, please, let's find who those equal opportunity jerks are now and let's work with them, because I don't want to have to defend your business saying, yeah, we were bad, but the plaintiff is worse. It's a very tough road to hoe. So bullying in the workplace can be just as bad as harassment. So conduct that can create liability, obviously if you yourself or your managers are engaging in the harassing or discriminatory behavior, that's liability. If you as the company knowingly allow it to occur, or you fail to properly investigate and respond to a complaint, the focus then shifts away from what really happened to how did you respond. And I see this a lot in the on the way out the door complaint. So you've got someone you fired, and they say, oh, well, I just want to let you know that so-and-so harassed me and asked me out on dates and grabbed my rear end in the kitchen over the last 6 months. And of course, in your mind, you're thinking, how true is this? Why would you wait till now? But you still have a duty, even if that person is on the way out the door, to get, I would stop and say, okay, I'm glad you told me. I want to get your statement. I want to find out exactly what happened. Because if they are telling the truth, it's not going to change the fact that they're fired. Like, you're still fired, honey. This is like, that's not going to change that. But what will change is if you do have an employee or a manager who has been harassing folks, we don't want that to continue just because that person is gone. So a lot of businesses will say, well, the person was on their way out the door, I don't need to do anything about it. No, you still need to do something about it because you still could have a person working there that is the harasser. And I've said this for years, don't be the story. Even well before the whole Me Too movement came along, don't be the story. Manager, standard, strict liability. If a manager, owner, supervisor, someone in a position of authority is doing the bad acts, it's straight to the top, strict liability, as good as the owner did it themselves. If it's a coworker or it's a customer or a vendor, once you know or have a reason to know, you have a duty to act. So if you observe the conduct and you think it's in violation of the policy, you now have a reason to know. If an employee comes forward and complains about a customer, a vendor, a coworker, a manager, you now know and have a reason to know, and now we have a duty to act.
The only exception to strict liability is if it's welcome, and that costs a lot of money to show something was welcome.
Right. Well, and again, that's the whole
Yeah.
unwelcomeness of it. And so we get into the situations where, you know, they say, oh, I was offended by these comments and these jokes, and then you find out that the person was also engaging in the same kinds of conducts and jokes. Again, at the end of the very long, expensive road of litigation, we might win. But even when you win these cases, you've lost because you're never going to get your money back. The plaintiffs' lawyers, they're going to get all their money back for the most part.
If they win.
If they win, because these statutes are written to be employee friendly. They are not employer friendly. Most of these statutes are written where you as the employer will never be able to recover your fees and costs. And you certainly won't get your life back in the time that you've spent litigating exhaustively these claims. So like I said, even if you win, you lose. You get the pat on the back that you defeated someone who brought a wrongful claim against your business, but quite frankly, even if you could get a judgment against them, could they satisfy it? Of course not, because if they had the money, they probably wouldn't have sued you to begin with. So it's kind of a vicious cycle.
It's a fee shifting structure. So when Congress put these laws in place, they did so thinking that the only way to get attorneys to represent these folks was to give them some incentive. And the incentive was if they win the case, then they get to ask the court for fees from the company. So,
right.
You know,
because these cases are generally taken on contingency by plaintiffs' lawyers. So.
It doesn't work the opposite way.
It doesn't work the opposite way for you. You have to pay your bills every month as they come, and you know the plaintiffs don't generally have to pay anything because their lawyer is going to take their cut from whatever they either get in a settlement or a judgment toward the end of the case or at some point in the case. So properly responding to a harassment complaint is obviously if you're going to share any of this with your managers, I've included don't do the investigation without guidance. So if you are an HR person, you obviously probably have the guidance you need, but you might also need outside counsel. You might need to pick up the phone and call me and say, hey, I'm getting ready to do an investigation. Do you have a checklist of things I can follow or some tips that I can follow? But what we don't want to have happen is managers just running amok, trying to conduct an investigation and taking statements from people, and half the time these things that are in these statements we don't want written down in a statement because they're discoverable. So you need to get guidance before you go running off and doing an investigation, but don't wait to do it because time is of the essence. Once you know or have reason to know, you got to jump on it because at some point, if it takes you months and months and months to get to the end of the investigation, there's going to be a lot of question about what was taking you so long, what were you doing. Don't tell them to go work it out with a harasser. That is not the way to not send them back and say it's unwelcome. Years ago, there was actually case law that said that the employee was supposed to tell the alleged harasser that it was unwelcome and to stop. at some point, someone wised up and said, quite frankly, if the person was comfortable with the conduct, then they probably wouldn't be unwelcoming to it. So we don't tell them to go back and work it out with the harasser.
Sort of the fox guard and the hen house.
Yeah,
analogy.
exactly. Don't take a position on whether or not they have a claim. Don't write in an email to other managers. Your emails are all discoverable. Don't say, hey, Sally was being harassed by Mark. That email is going to show up in the lawsuit down the road where you have already said so-and-so was harassed. Now, if we are having privileged emails, that's a whole other thing. If you hire us as your counsel, there could be privileged emails, but don't tell them that they have a claim. Don't tell them they don't have a valid claim.
Don't use the terms of art. Don't say this is sexual harassment.
Yeah.
Describe the conduct, the who, what, when, where, why of what occurred, but avoid jumping to what we would refer to as a legal conclusion.
Right, yeah. Don't tell them they should go see a lawyer or they should go to a government agency. That is the last thing we want these people to do, although we can't stop them from doing that if that's their choice to do it. And I don't know how many of you here have heard this from an employee you're terminating. I'm going to have my lawyer on this. I always laugh. Like, how do y'all have all these lawyers? Like, I don't even have a lawyer, and I am a lawyer. So they always have a lawyer. But we don't want to push them into the arms of these lawyers and government agencies. Never agree to keep it quiet. We can agree to handle an investigation confidentially, but we're not going to keep it quiet. Once you know, you got a duty to act. We can't retaliate against the person. Again, we can't take a negative action. I want to get to that screen here in a second. Again, don't be talking about it with other managers, employees, customers, only people that need to know and are intimately involved. We got to keep it confidential. If you're going to handle an investigation, these are my basic steps. You're going to get their full statement, the initial complaint. You're going to interview them. You're building a timeline, the who, what, where, when, how. When did this happen? Where did this happen? Because if you have cameras, you're going to want to go back and pull that video footage if you can. I can't tell you how many times we've relied on video footage recently when we're dealing with these investigations. You got to decide, do we need to put someone on a paid leave of absence or an unpaid leave of absence? Do we need to suspend somebody? Do we need to call a lawyer? Who's going to be part of the formal investigation? How are we going to do it? Who's going to conduct the interviews? What questions are we going to ask? We got the documentation. Then we've got to come to a conclusion. What's our conclusion? Do we got to fire somebody? Do we need to demote somebody? Do we need to move somebody? Firing the harasser is not always the solution. Sometimes it is, but it's not always, because again, depending on whether it's a manager or a coworker, sometimes remediating the conduct might be something short of termination, with a final written warning that if you do X again, then you will be fired. But these are things
suspension.
Suspension.
Michelle, I'd like to make a point on documentation, if you don't mind. A couple of best practices on documentation. If you are going to do documentation, please make sure it's legible, because as Michelle pointed out, we get these claims a year and a half, 2 years afterwards, and we can't make out some documentation sometimes. We can't read the handwriting. And if you're going to get a witness statement, I think the best practice is if you're getting a witness statement that's witness conduct, rather than you take the statement down and having that person sign it, have that witness put that statement in their own handwriting. And I've seen that be very helpful, because it's too easy for a witness 2 years down the road to just say, well, my manager put that in front of me and I just signed it. I didn't know what was on it. They can't disclaim it if it's all in their own handwriting. A couple of best practices there.
Okay. So I think we're pretty much about out of time. I already talked about retaliation. Again, you don't want to take an adverse action against somebody because they complained. Now, there might be things going on that you have to take an adverse action against somebody. It has nothing to do with the complaint. Sometimes there are things paralleling. That's where you definitely want to get with HR or your legal counsel and make sure that you're crossing the T's and dotting the I's, because we got to fire somebody while there's an ongoing complaint or investigation. We just want to be able to show that the complaint was not the catalyst for it. And even people who participate in the investigation, so witnesses, they can also bring retaliation claims too. So you want to keep those things in mind, that it's not just the person who is complained, but those who are engaged in the investigation as well.
And as with all things in life, timing is so important, particularly in retaliation cases.
And so I'll leave you with this as we go to break. Basically, you got to ask yourself, would I do this if my spouse were present, my grandma, my children? Would I say or engage in this conduct? Would I do these things or say these things if the person was in the protected class that I was talking about was there? What if I'm being recorded? Because these phones that people have, you know, they record everything, and it's nothing to like turn your phone on and be recording. So if you were being recorded, would you want to hear that back? Would you want to have to defend your words to a jury? If any of you ever had jury duty, I have. If you've ever been on jury duty, you're what, with 12 people, all different backgrounds, all different perceptions. Some of them don't know, you know, anything about anything, but they think they do because they watch a lot of court TV. You always got to get at least one person on your jury that watches court TV and knows everything. So, but if you've been on a jury, you know that the humor of the witnesses, the background, those things do not play to a jury. And so it's very hard when you've got 12 people who don't know you and know your personality, your background, your good character, are judging something that you did or said or did not do. So if you would not want to have to answer to a jury and have 12 people judge you in what you did or did not do, then don't do it.
On recordings, one comment on recordings. Surreptitious recordings are admissible evidence in the court of law. Louisiana, if I'm not mistaken, I know Mississippi is a one-party state. I think Louisiana is too. So that means only one party to the conversation has to know that conversation is being recorded. If we were a two-party state, then both parties would know, otherwise it'd be an illegal recording. So we're faced with that quite a bit. We get a surreptitious recording, an employee recording their supervisor. You may have a policy prohibiting recording in the workplace, but that doesn't mean that recording, if it's brought forward, becomes inadmissible in a piece of litigation. So I always tell managers, when you're talking to your employees, just assume you're being recorded.
Okay, great. Well, thank you.
We're going to take a break?
I think we've probably taken most of your break. 10-minute break.
All right, everyone. Again, my name is Steve Cupp. I wanted to give you a little bit about my background. I'm an Algiers kid. I was raised in Algiers. Went to I told Pam St. Pierre earlier I'm a proud graduate of O. Perry Walker High School, which no longer exists in that current form. Went to University of New Orleans and graduated. Found myself to University of Georgia Law School and got out in 1990. And since that I got out of school, I've been practicing management side labor and employment law. And it's really hard to think that 28 years have passed. Time flies by, especially in our area law, because it is a lot of fun, as Michelle covered a lot in the first half of this. But it kind of brings me to a good segue into the slide here. And what I'm going to talk about in the second half of the presentation today is really the leave laws that you have to comply with. What we find in the restaurant and hospitality industry is that these can be difficult laws because a lot of facilities don't have dedicated HR managers to pay attention to them and to comply with the paperwork requirements or other requirements that are set forth in the law. So we thought we'd take three today and talk about them. The Family Medical Leave Act, the Americans with Disabilities Act, and Americans with Disabilities Act Amendments Act, that's what the extra A's stand for, and the Pregnancy Discrimination Act. The FMLA was enacted in 1993, and it's gone through various changes over the years with regulations and different changes. The Americans with Disabilities Act is a 1990 law that was substantially changed in 2009, and it really changed to the extent that it's much more employee-friendly than it had to be, than it had been in the past. And of course, the Pregnancy Discrimination Act was passed in 1978, and when that was passed, of course, the Civil Rights Act was passed in 1964. When they passed this law, they amended it into the Title VII of the Civil Rights Act. So these are the three general ones we're going to talk about today, and I sort of lump them together because I know there's a lot of words on this board. I'm not going to read these slides to you. I just do want to point out some highlights. Give me a show of hands. How many in here have at least 50 employees within a 75-mile radius? Maybe about half. Okay. How about if you have multiple units, you have to aggregate those employees. Okay. So that's one. I don't know if that changes the hand count, but we have about half in here. If you don't have 50 employees within a 75-mile radius, you don't have to worry about the Family and Medical Leave Act.
Is that full-time employees?
No, it's any employees. And so you may have different units. You may have several restaurants. They may be under different corporate structure for corporate tax purposes. But under our area law, it's different. It's it's what they call enterprise coverage. And if they're controlled by the same corporate group, you're going to have to count all those employees for those 50 employees. So we were laughing at lunch today. We know some employers that are staying right at 48. They don't want to get to 50 because then they have to comply with the Family and Medical Leave Act. But of course, it provides 12 weeks of non-paid job-protected leave for an eligible employee. Eligible employee has to have worked for you at least 1 year. Doesn't have to be for a consecutive year. Okay, they could have worked for you 6 months in the past, left, and come back to work for you for 7 months. That's going to qualify. But when that employee requests leave, they must have worked for you for at least 1,250 hours during the preceding 12-month period. And that's a standard for that. Again, the law prohibits discrimination, harassment, or retaliation against employees, just as the laws Michelle spoke about in her presentation. The ADA prohibits discrimination, harassment, and retaliation against employees who have a disability, okay, a record of a disability, or who are regarded as disabled. Those second two prongs become tough sometimes. Frankly, sometimes it becomes tough to tell if someone has a disability, especially if it's a hidden disability, if it's a mental disability, a mental impairment. We have to figure that out. The law has a reasonable accommodation requirement, which we're going to talk about today, and that includes what they refer to as engaging in the interactive process. So if an employee asks for a reasonable accommodation, you got to figure out if they have a disability, and in most cases they're going to have some type of disability. You have to figure out what reasonable accommodation you're going to have to think about for the workplace. And it could, as I note here, it could include an extension of the 12 weeks of unpaid FMLA leave. By the way, going back to the FMLA, y'all may have heard in the news that there's going to be some law proposed coming forward with the current administration that's going to make paid leave, federal paid leave. So we'll see what happens there. The ADA applies to employers with 15 or more employees. How many in here have at least 15? I would say virtually everybody, right? So if you have 14, don't hire that 15th. You won't be hired by Title VII. Or I've had the opposite true. I had a small client with 16 employees ask me how they could fire 2 to get below 15. I don't really care for that, but
the problem is that the definition is 15 or more employees within 20 calendar weeks in the current or preceding calendar year.
Yeah, there's a count back.
You'd have to get out a couple years before you would no longer be covered.
There's a look back. And obviously under the ADA, there's no wait time for an employee to be covered. Once they come on, obviously an applicant can be covered as well. The Pregnancy Discrimination Act prohibits the same conduct against pregnant employees because of pregnancy, childbirth, or related medical conditions. Okay, these are, again, all 3 of these are federal laws. As with most Title VII laws, it applies to employers with 15 or more employees, and again, there's no wait time. The FMLA is enforced by the Wage and Hour Division of the Department of Labor. They come out with these stats every year. I think the fiscal year in September 30th of each year, if I'm not mistaken.
I think so.
Yeah, so they come out with the stats. So last year they processed 1,165 complaints dealing with some sort of FML issue, and they found this. I thought this was pretty striking. They found violations in 50% of the complaints they investigated. And contrast that with the EEOC, Michelle. They usually issue a no-cause determination in 97% of the cases.
Probably, yeah.
So we're still seeing a lot of trouble with employers complying with various aspects of the Family Medical Leave Act. The most common complaints are someone was terminated because they took leave, the employee was discriminated against somehow, or the refusal to grant leave. I haven't had too many refusal cases, but where I litigate this mostly when they come to my desk is the termination because of taking leave. Because invariably someone's going to go out on FMLA leave, and then you're going to find out how crappy of a job they've been doing because their replacement does, a lot better. And you're going to say, well, I didn't know that they weren't, paying invoices or doing their job. And now I'm finding out, now that they're out, that there's a bunch of stuff that hasn't been done. And that becomes the very tricky question about what you do at that point. And if you are going to discharge the employee, when do you do it, and how do you go about doing it?
And I think we both spend a fair amount of time answering questions about how do you handle when you find that someone needs FMLA, how do you handle the paperwork, what kind of notices. We actually have an FMLA packet, and if you email me, I can send it to you. as part of your benefit as being an LRA member. So I did put cards back there today, but my email is also on the screen, but we can provide that to you. It has a sample policy, has a copy of the poster, it has the forms, and it gives you a checklist of everything that you need to do. And I spend a lot of time moving the chess pieces, helping employers deal with FMLA leaves, like Steve is describing.
I've just discovered that Michelle has a treasure trove of forms on our desk site system at work, and we're not going to tell anybody else that. It's just between us and a few other attorneys.
It's a secret.
Under the Department of Labor, unlike Title VII, where someone has to go to the EEOC first before they can file a lawsuit against you, here they can go straight into court. They can go to the Department of Labor and file a complaint against you, and the Department of Labor will investigate it, but they don't have to. There's no what we call exhaustion requirement under this law. And what really makes it troublesome too is that the employee has 2 years to file a lawsuit, and possibly up to 3 years if it's a willful violation. So what we see when we have these older type lawsuits is someone takes leave, they come back, within a month they get fired, but then they get another job, and then they get fired from that 6 months later, and then they can't find another job, and they go, I'm going to sue my employer because I think they discriminated against me or retaliated against me for taking leave. So it can be problematic. Again, you see this elongation of the litigation period, and lots of times Michelle and I are really Monday morning quarterbacking if we weren't involved in the discussions at the front end, trying to figure out what happened several years down the road. Let's look at the ADA. ADA is enforced by the EEOC. Before the employee can file a lawsuit under this federal law, they have to file a charge within 300 days of the adverse action. That's in Louisiana. In Mississippi, it's 180 days, and it's 300 days in Louisiana because Louisiana has a state agency as well. And for states that have a state agency, the period is lengthier. My experience with the EEOC I deal with them mostly out of Mobile, Alabama, and Jackson, some out of New Orleans. They take about 6 to 8 months. I do have some that have been pending longer. But after the agency processes the charge and issues what they call a right to sue notice to the employee, which is issued well over 95% of the time, the employee then has 90 days to go in and file a lawsuit against you from getting that notice. So a lot of times when we get lawsuits in, we're looking closely at that timing to see if they missed various deadlines to sue. In 2017, I think Michelle threw these up earlier, there were ADA charges accounted for 31.1% of all charges, or at least that was the claim made in 31.1% of them. And the last one is the most common impairment. So there's a whole list. If you go on the EEOC website and dig in a little bit, you can get to these impairments, and there's probably about 40 or 50 that are listed. I listed the most common. Orthopedic problems, back problems, anxiety disorder, some stuff we would think clearly are disabilities, cancer, depression, diabetes. But look at the last two, which are very interesting. Or three, you're regarded as, you may not have a disability, but your employer regards you as having one. It could be covered by law. You have a record of a disability. You're a rehabilitated drug user, no longer using drugs. You could have a record of a disability. Or the relationship or associational type of disability, if you have a disabled child, a disabled spouse, you're not disabled yourself, but you're related to someone who's disabled, and you need some sort of accommodations because of that issue. All right.
It's called caregiver discrimination. Generally, we see that.
Pregnancy Discrimination Act is really the same as the Americans with Disabilities Act as far as how it's enforced. They must file a charge before going into the courthouse. Same as restrictions apply. And as you see that there were significantly less charges filed last year for pregnancy discrimination. I think that's a good sign that people understand they can't discriminate against a pregnant employee. But it does happen, and a lot of times it's stray remarks, and a lot of times, I've had situations, I know Michelle has too, where the employer took some action that was detrimental to the pregnant employee, really out of a good heart, because they thought that if that employee was going to have to carry that 40-pound tray or 30-pound tray, that it could cause some harm to the baby, okay, and they could be liable for that. That's not the way it works. You can't discriminate against that employee because of that issue. Now they have to be able to perform the essential functions of the job, again, who may have to accommodate their pregnancy. So again, that's where those laws overlap.
But we do get a lot of questions like, I've got a pregnant employee, what do I do? It's not like, okay, women have been having babies for a long time, and it's not like you become a delicate flower as soon as you get pregnant. But we do get a lot of calls of concerns about women not being able to perform certain aspects of their job. And the woman hasn't even said anything yet that they can't do that aspect of their job. So we have to be careful about imparting what we think a woman can't do when she's pregnant versus when she comes and says, I need an accommodation, my doctor has said I can no longer do these certain functions. So appreciate the concern when someone says they're pregnant, but a lot of times we have seen employers go overboard the wrong direction.
I had a client that said, well, you can no longer work here if you're showing. Well, that wasn't good. We had a problem with that. FMLA, I think most people know what the leave is, what type of leave you can get. By far the most common leave I've dealt with is the employee taking leave for either the birth of a child, pregnancy related, or to care for their own serious health condition. Those are the most common. And again, these slides are going to be available for you to get and mull over a little bit more. But one thing I think is interesting in the third paragraph, that leave can be taken in one block at full 12 weeks, okay? Or it can be intermittent or reduced schedule. The one that drives me the most crazy is intermittent leave. And I'll throw it out there. I've never been afflicted with migraine headaches, but I know people who are, and I know they're debilitating. And migraine headaches are going to be considered a disability, but it also subjects itself to the most abuse because the employee's calling in on a Friday and a Monday morning saying they have a migraine and can't come to work until later that day. And it's tough to deal with, but once you start seeing that pattern of absences, we can deal with that. If it's always a Friday, always a Monday, maybe things we could do there.
This is what I tell employers about FMLA and ADA accommodations. It's a chess game. So you find out that a person may have a need for leave, and we make our move. We give them the notice. They then may have to bring back a healthcare certification form if it's for that reason. And so they bring that back, and we look at it, and we make our next move, and we decide whether it's designated as leave or not. And then the person goes out. And if the person's out consecutively, then we know about 9-10 weeks in, we're going to start reaching out to that person. Hey, you're going to be coming back at the end of 12 weeks, or if you can't, we need to know from your doctor. You know, we start that dialogue. They can't come back. Then we make another move, and we give them a little more time, and then they still can't back, and we make another move. Or they're on intermittent leave, and the intermittent leave covers so many absences or so many appointments, and they start abusing it. So we make another chess move, and we say we need a new certification. So it really is a chess game when you're dealing with these. There's no like one right answer every single time. It's very fact intensive, and so HR or legal counsel who can really guide you through that process. But I mean, even today before I came here, I was writing a letter to a doctor, ghostwriting a letter to a doctor, to do a safety evaluation for someone under the ADA, being concerned that they were not safe to perform their job, and how we had to make that move to get that information before we can then take our next step.
Yeah.
So just think of it as a chess game or a checker game, and you're always looking at the way your next move and how you're going to move it.
It's complicated. It can be complicated.
It's not. The people that wrote these laws are not the ones that are implementing these laws and having to live with them every day. I assure you, if they did, they would rethink the way they have set all of this up.
And look, the law is complicated enough if you go and read the text of the law, but what's really important for us as practitioners, it goes to the regulations. There's a whole lengthy list of regulations that govern, that define various things and tells you what you have to do. Again, that can be found online, but it's not the easiest thing in the world. One thing I've noticed of late, I deal with a lot of automobile dealerships, in particular in Mississippi, that they have the requisite number of employees. They have a poster on the bulletin board, and they have a handbook, but they don't have the FMLA notice in their handbook. That has to be, there's a requirement that it has to be in your handbook. Michelle was kind enough to send me one that was less than 3 pages long the other day, because some of these handbook provisions can get up to 7 and 8 pages, particularly when we had to add the military caregiver leave. And we're not going to discuss that today, but as you see in the first paragraph, if you're dealing with a military leave with qualifying exigencies, the leave can be up to 26 weeks in the year. And again, that's
to piggyback on what Steve is saying, You are not required to have an employee handbook, though I highly recommend that you do have one, because how are you going to set forth your expectations for your employees if you don't have one? How are you going to govern the conduct? But if you have 50 employees, regardless of whether there's 50 within 75 miles, once you hit 50, by law, you have to put the poster on your board and you have to have an FMLA policy, whether it's a standalone policy or in your employee handbook. Even if you have nobody who'd be eligible to take it because you don't have 50 employees within 75 miles, you still have to have a written policy.
It's really a technical compliance issue. If you're doing everything else right with respect to the employee, you're not going to get dinged too badly by the Department of Labor if they come in and find that you don't have the policy in your handbook, but they're going to ask you to put one in there. And so that's what we do. And Michelle touched on the paperwork. I call it paperwork intensive. One thing that you have to remember is that there's no magic words for the employee to invoke their request for leave. And this is kind of frustrating. It would be great if the law says you have to go to your employer and say you want FMLA leave before that employer is under an obligation to go through this process. That's not the case. It could be a situation where you know that an employee has been in the hospital for 5 days or for 4 days or whatever. They've had a lengthy hospital stay. You have to be thinking in your mind, and more importantly, your manager, your frontline manager who manages that employee, has to be thinking this may trigger some sort of FMLA leave provision that we have to look into, assuming the employee is eligible and you're a covered employer. So there's really 3 primary forms that I look at. And these are again, we have forms, they're taking from these, but these are wage and hour forms. The 380E and the 380F is really the employee's only obligation under this law, one of their few obligations anyway. And that's for them to take this form and bring it to their doctor and get their doctor to fill it out, certifying that they're in need of this leave for whatever reason. It has language as to what's the expected duration of the leave. And that employee has 15 days under the regulations to get that back to you. That 15 days could be extended for various reasons. One of the issues I've had with this is that a lot of times the employee will say, just fax it to my doctor. No, you take it to your doctor. We're out of this certification issue. Well, I can't pay for it. Who's going to pay for my doctor visits? Well, that's the employee's responsibility. It's not the employer's responsibility to pay for this visit. Okay, so that question frequently comes up from employees that say they can't afford a doctor's visit to get the certification. But you have to insist on it. That's their responsibility. The other 380 form is for a family member's serious health conditions, very, very similar rather than the employees. So what that triggers are the next 2 notices, which are the most critical notices. And as I mentioned in the bottom paragraph, these 2 notices provide notice of the, if you're going to approve it, what are the responsibilities of the employee to continue to pay their health care premiums while they're on leave, or their portion of it, whether accrued paid leave will be paid concurrently, will be paid and will run concurrently with the unpaid leave under the FMLA. It deals with periodic reports. It also has a section on there if you're going to deny it. You got to provide this notice to the employee. So there's a lot of opportunities for missteps along the way with the FMLA paperwork.
And remember that FMLA can run concurrently with a workers' comp leave. A lot of businesses forget that if someone is out on a leave of absence because of a work-related injury, you can run this simultaneously, but you got to do the notices and do the tracking properly, because otherwise these workers' comp leaves can become an abyss. I have employers call me and say, they've been out on workers' comp leave for 2 years. I'm like, why? Why do we still have them as an
why are
employee?
they still on? Why are they still on the system?
But they hadn't done the FMLA. And so now I'm like, okay, now we got to clean up our mess here, and we got to figure this out. So.
And we can be aggressive in that sometimes by saying, no, 12 weeks means 12 weeks regardless of whether, but you just don't want to get into that argument in the court system or with the Department of Labor. So it's always better to comply with this notice. And I found myself, at least of late, getting calls saying, Steve, I got this guy and this lady that want to go out on leave. Well, what am I supposed to do? And they don't even have the forms there. So we got to send them the forms and instruct them on how to use it. So very critical for FMLA compliance. Let's talk about some ADA basics. Again, Michelle touched on some of this, but you have to be a qualified individual with a disability in order to be protected under the ADA. And that's defined as someone with a physical or mental impairment that substantially limits a major life activity. These are all terms of art under this law and have various meanings under the law. I think one of the most important things here to take away is that when the Amendments Act was passed in 2009, that act was passed because Congress thought that the courts were too badly restricting the ADA, that it was very hard for someone to successfully bring a Disability Act claim. So the Amendments Act expanded it, okay, and made it, to make it easier, where the focus is no longer on whether someone has a disability and trying to determine that. We almost have to assume, well, in most cases, that they do have a disability. The focus then becomes on the reasonable accommodation that you're going to make for them. And that can take, of course, take many forms. And to get through that reasonable accommodation, you have to be equipped and trained and comfortable enough to engage in what's called the interactive process. You know, I get supervisors or owners sometimes, I don't want to talk to them about it. Well, you have to, because we have to talk about what they believe, what accommodation they believe they could use to perform the essential functions of the job. It doesn't mean that we're going to give them that accommodation, because it may be impractical, or there may be some other accommodation you can give them to allow them to perform the essential functions of the job. One thing that's pretty cool about it still is that the courts have pretty much come out and said that attendance at work is an essential function of the job. I hear some chuckles. That would make sense, right? Regular attendance at work, but this is more and more important these days because of the what's the term I'm thinking of when you work off site?
Remotely.
Remote, yeah, just remote work. And Michelle and I work remotely all the time. I mean, we can do it in our job, but a lot of jobs you can't do it.
Let me say one thing about the interactive process and reasonable accommodation. So part of my background is I actually used to work with people with disabilities. I actually used to put them to work. I would go learn the job, and then I would job coach them and train them, and then I'd help them retain the job. And so I have learned through that line of work and this line of work that when there's some need for accommodation, generally to accommodate somebody with a disability will cost a business less than $500. In fact, most of the time, it doesn't cost you anything. To accommodate someone with a disability. But a lot of times there are so many disabilities, particularly ones that we can't see, and we don't really know how to help people. There's a great resource called the Job Accommodation Network, JAN Network, and if you go on there, it talks about all different kinds of disabilities, and it talks about different ways that you can accommodate people with those disabilities. So if you're in a situation where you're having an interactive process dialogue, you know, with the person, and they're like, I don't know what you can do to help me. Maybe you've gotten some documentation from the doctor that gives some suggestions, but that's not really going to work either. You go to this resource and maybe you get some ideas and help come up with an accommodation plan for them using that.
Let me tell you how easy it can be, and we've all seen it because we've all been to a Walmart, right? So the people greeters in Walmart occasionally are sitting on have a stool right there that they sit on. And that was because of this, that's an accommodation that allows that person who may or may not have a disability, a lot of times they do if they're in that position, that they give them to be able to perform their jobs, to take a little respite every once in a while. So the providing of a stool in that case would be a reasonable accommodation. Of course, there are some accommodations that are requested that may pose an undue hardship upon you. But like with everything in life, when you're going to try to defend something or try to not do something that you may be supposed to do under the law, the burden's going to be on you to prove or to show that that is an undue hardship. Most of the time we think about litigation as the plaintiff having the burden of proof, but there's certain defenses that if you're going to bring as a company that you're going to have to bring on that burden. You're going to have to show that it is an undue hardship. And as Michelle mentioned, I think overwhelmingly it's, you know, the overwhelming amount of accommodations aren't that expensive to implement.
So you'd have to show an undue hardship means that it's going to be economically unfeasible. Generally, that's what you have to look at it as. So would I have to hire another person in order to accommodate this employee? Would I have to then hire another employee to do their other half of their job? That would be an undue hardship.
Yeah.
You know, would I have to change out the management? You know, would I have to make all, you know, move walls and things like that? Then it might be an undue hardship.
Or let me bring it closer to home. What if someone says, I have a disability that doesn't allow me to carry that 20-pound tray, but I can take the order at the table. Maybe someone else can bring that tray for me.
But they even make trays for wheelchairs. I mean, if you had someone in a wheelchair who was a server, they actually make trays that clamp on so they can serve at the table. I mean, typically, if an employer calls me and says, I've got this person with a disability and I don't know what to do, we can usually figure something out. A lot of times can come up. There's so much cool creative technology and businesses out there that do this for a living. There's a lot of ways to bring people with disabilities into your workforce and support them. I think we might be out of time.
We are out of time? Okay.
We're out of
Wendy's
time.
eyeballing us. So.
Okay. I didn't see you
Hi.
eyeballing, Wendy.
Thank you guys very
Okay,
much.
you're welcome.
For all of you in the audience, we are recording this session, videoing it. Max over here is videoing it for us. And we're going to provide you with all the PowerPoint presentations immediately afterwards so that you can go through them. And if you have any further questions beyond today's session, you can call us anytime at the LRA as members. You can ask for me or Erica, or you can call Michelle and Stephen directly. That's one of the benefits, and that's the most used benefit, actually, that we find. We handle a lot of these calls every day. So,
Wendy, can I mention one thing?
Sure.
And this is very quickly because we were going to transition into the last 3 slides. I just want to mention it. We thought it important anytime we get restaurant and hospitality people together, there's 3 primary wage and hour things we want you to concentrate on. Tip credit compliance, tip pool compliance, and making sure you're paying the proper, making sure people are reporting tips and you're paying minimum wage and you're paying the proper amount for overtime for a tipped employee. Okay, I know most of you in here comply with that, but we just see it over and over again where people are not complying in those 3 areas. So if you have questions about those, come see us before you leave.
Overtime for your tipped employees is not based on 213, it's based on the full minimum wage. So don't do 1.5 times 213 and think that you're paying the overtime right. We can still take a tip credit on it, but you're not paying it right if you're using 213 as your base wage for overtime.
We see that repeatedly.
Repeatedly.
Even today.
And don't assume your payroll companies and your accountants. It's your duty as the employer to make sure that you're paying them properly and that the wages are getting paid properly because you're the employer. So,
Okay. All right, I think we're transitioning now.
all right. Helene Wall with Postlethwaite Netterville is going to share with us the role of an HR consultant and how they can augment your staff. And while we...
So, Wendy, thank you. First, I want to thank Stan for letting us come today, and I apologize for the allergies in my voice. I think everybody here has probably got a little bit of that lately. But I'm here today as a representative of Postlethwaite Netterville. We are a tax, accounting, attest services, and consulting firm in Baton Rouge, Metairie, and 7 other locations. And so I wanted to go through, in a very short amount of time, some things that we do to help our restaurant and hospitality clients that I think might be very beneficial to you. So a little bit about Postlethwaite Netterville. 65-year-old firm. We're in 9 locations, in the top 100 accounting firms. We have got people that help in all sorts of areas for our business clients, whether it's tax, accounting, technology, and consulting, which is what we're going to talk about today. We do something that's very, very unusual. We have a very holistic approach when we work with our clients because we find that many times it's more than just one area of the business that needs attention. So when we work through these things, we get into consulting, which is where I am. The consulting role wears a lot of different hats, just like you guys do. So we're going to talk a little bit about that today. The way we do it is very, very unique. We get involved with our clients at the base level, and we talk about people, processes, and technology. Because what we find is it's not always just one area. We get in and we start looking at things like employee behavior. We look at things that escalate up to the law firm. So when you get in touch with Michelle and Steve, you need to be prepared because they're going to do the best they can when you're prepared. Today's special for you guys is all about risk management. These are things that I think you guys, Steve, you and Michelle touched on these very, very broadly and giving them some great information. When we work with our clients, and I'm able to speak a little bit better, we get in and talk to you about how do you deal with these things on a day-to-day basis. What does your infrastructure look like? What is it like when you hear these things being talked about in the restaurant, in the office, among your customers? Things that get your attention, I get harassed every day. Don't want to get anybody fired, but some of the things that Michelle touched on earlier. He keeps asking me out. What do I do? I don't know who to talk to. If you don't have human resources in your organization, I strongly encourage you, don't go to bed tonight until you figure out a way to make a good business case to get the help you need. We work with quite a few of you in the audience here, and I'm really glad to see you here today. You guys know that these things happen every single day. It's an integral part of dealing with people. That's what we do. You're in the restaurant hospitality business. You're with people all day long. These things happen all day long. The compliance side. So I like to talk a lot about preparation. My job as a consultant is to make you be the best prepared client that can ever call Michelle and Steve. So when it comes to that documentation, to the paperwork, to making sure you're onboarding your employees correctly, the I-9 forms, the employment paperwork, all of those things that go into rolling up to asking for legal advice. So I am not a labor attorney, nor do I play one in my videos. I know where that line is drawn, and it's very important that we keep that line in place. These things come up day to day, and if you're shooting from the hip and you really don't have good procedures in place, you haven't trained the managers that are funneling these things up to the CFO, the CEO, the general manager, whomever. You're going to get different decisions made with different people involved, and guess what? We're human. So the decision I make may be different than the decision my partner makes. Now you potentially have some discrimination. Now it rolls up the hill to legal. We want to help you not have to go that far if you can. Those policies and procedures that were talked about as well. If you have your handbook, do people actually know how to use it? Do you have the right information in the handbook? If you're in multiple states and you have multiple locations, does everybody have the same version? Are those versions legal? Have they been looked at it by Labor Council? Have they been looked at? All of the things that go into that on the day-to-day attendance issues. How do people call in when they're going to be late? What happens if they use their cell phone when they're working? What do those policies look like? If you don't get that stuff in front of your employees, how do you really expect to hold them accountable to it? Turn that around for just a minute. Would you want to be held accountable to something that you had never seen in print, never had presented to you so that you understood how to deal with it, and really didn't know who to go talk to if you had a problem? That's the kind of in-the-weeds stuff that Postlethwaite Netterville is great at. We get down in there and we help you lay that groundwork to make sure that when it gets up to legal, they're ready and they can look at it and say, this is going to be a slam dunk because you've got all your ducks in a row. On the administration side, there's a lot of transactional day-to-day things that take place. You know that. Recruiting is probably, wouldn't y'all say, one of the hardest things to do in the restaurant business? I mean, it's like a revolving door, right? And there's so much paperwork and so much documentation. If you don't have good technology and good systems to make that seamless, steps get skipped, especially if you have numerous people involved in the process. If technology is a problem, if the reporting that you get from the technology is non-existent, if it's difficult for you to do all of these tasks because you don't have skilled or qualified human resources people helping you, that's the trifecta for disaster. That's the last thing you want. When you need help, there are ample people within the LRA to help you. It's amazing what you guys have available to you as a member of this organization. So you can go to the NRA's website and get a lot of good information, education, helpful tips. I've been looking at it the last few days and it's really very good. You get to your own membership here with the LRA, the resources and information that is available to you is really tremendous. Legal guidance is there when you need it. In between your resources, your education and information and legal is where Postlethwaite and Netterville can fill in for you. We can be the boots on the ground. We can be the staff augmentation. We can be your outsourced service provider, whether it's in HR, technology, processes, whatever you need. Somebody's got to get in there and get the grunt work done, and we're really good at that. I love this stuff. Don't know why, it's just a thing. I really like it. I like it getting organized. I like it so that you can do your job and get out of these weeds. This is how we do it. It's a real detailed process that we go through, and we find it very helpful because it's interactive with you. We don't come in there and look around and say, okay, this is what you need to do, and send you a great big bill. We get in there with you and we work through all of the details. The first thing we start with is an assessment. What is going on? Where are your pain points? Where do we see risk? Where do we see opportunities for improvement? What's the culture like? What is going on that you need to get fixed right now? And then we'll put together a plan for you. And all of this goes to some of those compliance things that make sure you're on the right track to start with. Getting the files straight, getting the I-9s done. How many people love to do I-9 forms? Right? It's difficult. I mean, I think it's self-defeating, the form itself. Those things can cost you money if they're wrong. So you need to make sure that you have a system and a procedure in place and people are trained. If you have a lot of turnover in your administrative group, so the person doing onboarding and I-9s yesterday is not there tomorrow, and oh well, somebody left some notes, so we'll just do it the way she did it or he did it, and that was wrong. So now you're just building a hill, and it's going to be a long ride down, I can tell you. So building that infrastructure is what we do, whether it's manual processes, technology, doesn't really matter. We need to see what you need so that we can help you build it. Once we understand what your needs are in that assessment, then we can come up with a roadmap. Then we can come up with a plan that you can develop and implement and do it in stages, because you don't want to roll out a bunch of changes all at once. That's hard. It's hard on employees. It's really hard on the administrative staff. But looking at all of those things that build who you are, whether you need a compensation plan, total reward system, what do your benefits look like? What does your comp structure look like? How is your tipping going? Do you have management involved in that? Are you following the rules the right way? All of those things that go into the developmental piece. Do you have the right system to control all of this data? Is it secured? Do you have paper files scattered in 5 file cabinets in 4 different restaurants? Love that one. That's tough to get your arms around. You guys have reporting requirements to do for equal employment, your EEO forms. If you don't have all of that applicant and employee data in your system where you can quickly and accurately generate those forms and reports, you're going to have a problem come reporting time. So we look at systems, we look at who's getting the data, how it's coming in, how it's being managed, collected, secured, and then how you can best use it. Once we know the wheels are firmly on the bus, and not until, then we start looking at Postlethwaite transitioning out. Do you need us to help you recruit for an HR person? Do you need to keep us on board in kind of a staff augmentation role? Do you need one of our accountants to come in and work with you periodically, or a new system selection or implementation? So our team works together. It's not just HR. I've always been a firm believer that it's never just human resources when it comes to trying to get a company going right. Yes, we deal with the human side and the employees all day long. But the key is that all of these pieces have to work very, very cohesively to make this function so that you're not driving yourself crazy all day long. You guys have other things to do. So making sure that we put that secondary piece, that plan in place that makes sense for you and that can continue when we're there to help you periodically or when we're gone. The really cool thing about what we do, especially in the human resources arena, is we work a lot with organizations that have a full HR team. Those of you who do payroll or accounting or recruitment or HR functions know that you really can't tackle big projects along with the day-to-day stuff that goes on. So we can come in and supplement and help you do those big projects. We've never done an audit of our employment and I-9 files, and we've got 4,000 to go through. We'll never do that, but we know that that is a ticking time bomb. We can come in and do that. We do that a lot. We compile the information, we train you on the right process, and then we'll get in touch with legal with you to say, hey, this is what we found. We need a legal opinion now to make sure that these guys know what to do, whether they should try to fix this stuff, leave it as is, keep moving. That's where we pass it over to Michelle and Steve. So keep in mind that we're kind of the middle ground to help you when you're in the weeds, getting all of this stuff pulled together. We had a very short time for me to speak to you today, and again, I appreciate your patience with my voice problems I'm having. I'm going to be here for questions and answers in a little while. If you need to get in touch with me, we have some really good materials in the back. I encourage you to pick them up. Wendy, I think you said you're going to send the slides out to everyone. And so anything that we can help you with, again, my name is Helene Wall. I'll be glad to answer any questions that you have. Thanks
All
so
right.
much.
Thanks, Helene. All right, John O'Brien, come on down. John O'Brien is with Arthur J. Gallagher, and he's been working with our association for a number of years. And he's going to talk to us about
The best topic.
the best topic, insurance coverages you may want to consider.
All right, let's see, we're good here? Everyone can hear me? All right. I'm John O'Brien. I'm with Arthur J. Gallagher. We're an insurance brokerage firm. It's a worldwide company. We have about 24,000 employees. We do a little over $5 billion in revenues. And I have been insuring restaurants for quite a while, since 1987 in New Orleans. Many of the local restaurants are my customers. And I'm going to try to help you walk through quickly, like going through Algebra 3, insurance for employment practices liability. And I thank the Restaurant Association and all of you. During mental weakness, I have participated in some ownership in some restaurants. It's much harder than insurance, I can assure you that. Boy, I don't know why I did that, but I've certainly learned the industry more than I wanted to. Qualifications. I have been doing employment practices liability insurance since 1997. We started a program in San Francisco in a joint venture with New Orleans, and the program has grown in the 21 years to cover about 25,000 locations nationwide. We currently have about 350,000 restaurant employees in the program, and I'm just going to go through you what I've seen since one of the Harveys. Harvey Weinstein, my two Harveys, Hurricane Harvey and Harvey Weinstein, changed insurance. So what we see in employment practice liability are we're going to go through a few examples of actual claims, typical claims, what is an EPL insurance policy, what and how do we protect my businesses from civil rights violations, general insurance conditions and usual limits, important policy coverages and costs, listing of, what am I doing? I'll come back. Listing of Louisiana EPL insurers that you can go to or have your agent go to. I'm going to give you our go-to insurance companies and what has always been competitive for us, so that you can go to your agent and probably get the best quality coverage at the lowest cost. And just resources that your employment practices liability insurers will provide you as buying their policy. It's free resources, 800 numbers, human resources, types of tools, Spanish, English, those type of things. So here we go. Going next. All owners, this is what I've seen, all owners, executives of insurance companies are now like celebrities. I don't care if you're in Franklinton, Monroe, or New Orleans, you are a celebrity. What comes out of your mouth is very important. The media is looking for you. They're looking for you to try to sell papers. They're looking for you to see if anything has gone wrong, because what we've seen, and as we saw today, just look at the Mississippi State coach and the Ford Motor Company president stepping down because he had sexual misconduct. The media is out fishing for you, and you are a celebrity in your community. I don't care how big or small it is. You are a celebrity, and they're looking for you, and you have to look at yourself like that and understand whatever you do, whatever action you have, it can have an impact. Brand management. EPL has now become brand management. In other words, your restaurant is a brand. No matter, again, even if it's in a small community, everybody knows who you are. Everybody knows what your restaurant is. And if you don't take the proper steps to protect yourself and do the right things, not to have violations, you're going to hurt your brand. And then you can hurt it, you can devastate it. It's been bone crushing. I've been involved in 3 of the major sexual harassment restaurateur issues in the nation. And it was brutal. So you are trying to manage your brand, and by doing the proper steps, your brand will continue on. Moral turpitude. I'm seeing a lot of this out of New York. If you have contracts, mortgages, leases, if you're a franchisee, if you're in a hotel, there's a little clause usually in those contracts which is moral turpitude, which means they can immediately terminate your contract because you've had allegations of sexual harassment. And in New York, which is a state which we insure many restaurants, if people have favorable leases, they're looking to terminate contracts. You could have your loan called sometimes because of a moral turpitude contract because of a sexual harassment allegation. It's very important that you take what Steve and Michelle did and put that into practice, because at the end result, you could lose a lot. Owners and executives are held to a much higher standard. Man, I can't tell you what I've been through. No texts, no emails, no Snapchat, no Facebook, no discussions, nothing involving sexual type issues or anything with your employees. Just can't happen. Cannot happen, cannot happen, because it will ultimately hurt you. There will be consequences. Weigh the consequences of getting romantically involved with any employee in your organization. It is a serious, serious decision. The sensitivity of the media and the courts and the EEOC is at the highest that I've seen it in 22 years. You do not generally want to do that. It's a major consequence, and we tell our clients, if you're involved in something, you better sit down and discuss and weigh what the consequences and your exposures are, because they could be significant, and you've seen what's happened in the media. It is a serious, serious issue. You're probably putting your brand at risk, and you can put everything you've worked for 20, 30, 40 years at risk. We have not seen a significant increase in severe large claims. It's media driven. We have 25,000 restaurants covered. Our large claims continue to be sort of in the same pattern. You're seeing a lot of media driven issues related to it, but when it comes to actually reviewing what the losses are and how much they have actual quantified factual evidence of things that we're going to pay on, it's not as big as we had anticipated. We are seeing a frequency of nonsense claims. I mean, we are seeing nonsense claims literally probably doubled. Every week we're seeing things, a server was bumped in her breast by a waiter. She put in a claim. You know, those types of things are just coming. It's nonsense claims, and I think that will go away with the tide when the media hype goes down. Let me just tell you, there will always be back of the house, front of the house, on the line talk. And we know that, your insurers know that, the courts know that. This is something that you're not going to eliminate. When we go in and we talk to people who have these large claims and they have the EEOC charges and everything, and they're just freaking out because they think that they're going to be paying hundreds of thousands or millions of dollars. It's the nature of the beast, and you all know that you're not going to eliminate a lot of that line talk. It's part of it. You do your best, you control it, you do what you do with the documentation, following your attorneys and your human resources. But we know it can't be eliminated. You talked about tip sharing. That's a big deal. Follow your attorneys and whatnot about tip sharing. Never do anything off the clock. Stop any cash payment. Try not to do favoritism. And again, communication is vitally important between you and your staff. These are some just recent lawsuits that we've had. A restaurant in the French Quarter, $200,000 for race discrimination because of jokes. It was jokes, kitchen jokes, African-American jokes, and it was prevalent. They made the supervisor aware. They didn't stop. Ended up $312,000. New Orleans restaurant, Fair Labor Standard Act class action lawsuit, a New Orleans restaurant bar, tip pooling issues. It was tip pooling again issues, and it wasn't proper notification of the tax credit. The owners ended up having to pay $250,000. There was over $100,000 worth of defense costs and attorney's costs related to that. Baton Rouge restaurant, sexual harassment, allowing sexual discussions, touching and things going on. We ended up paying $450,000 for that loss. This is a paraplegic man sues numerous restaurants. This wheelchair-bound paraplegic man was targeting restaurants that were not ADA compliant. And he would go in, he would tell them, he would write the letter. Many of them didn't respond. He would put in an EEOC claim, and of course they weren't ADA compliant, and ultimately there's a violation, so we ended up paying that, and he got tens and tens of thousands of dollars from numerous locations that he targeted and found out about. This is, the huge one. This was a discrimination in Georgia, $8.7 million, actively discriminating, African Americans being actively discriminated against. It was known, they were doing it on purpose, and they didn't do anything about it, and they got crushed, and so did we. Typical claims, restaurant owners, I think you've been through this: race discrimination, hostile environment. The new buzzword you're gonna get is mental trauma. It's mental trauma. I had, the discrimination, the jokes, or the harassment, or the being cornered to a sexual talk is giving me mental trauma, and that's what we're seeing a lot of the basis of some of our claims in litigation. Sexual harassment, hostile environment, again, wrongful termination, equal pay violations, failure to promote, noncompliance with the American Disabilities Act. Again, the mental trauma keeps going on. Third parties, you can have third parties, your vendors, your guests, your clients that actually, you have some clients that have, demand the same servers each time. And if they're stating different things, Betty, I really like you, you have a beautiful body, I'd really like to go out with you, and they bring those things up, man, you've got to address those issues, and you have to address them with your clients because it is an absolute violation of their civil rights. Failure to hire due to discrepancy, ADA access, which we went through with the wheelchair individual. What is employment practices liability insurance? It's an insurance that provides the funding to cover the legal costs and settlement of claims related to civil rights violations. EPL insurance provides resources to support your human resources department to help your business to comply with civil rights laws. So it's basically transferring the risk. We hire the attorneys, and we pay the settlements and judgments should you be found to be guilty of violation. EPL is a controllable exposure. This isn't like a hurricane, fire, or anything. If you follow what your attorneys do, or Postlethwaite Netterville, this is controllable. You will not be in violation. If you do what you're supposed to do, your claim will not escalate to some massive amount. If you have the proper documentation, so you have the correct employment applications, you have the correct handbooks in compliance with current and state laws. You get with Steve or Michelle, and your attorney makes sure that they're reviewed properly. You have an EPL insurance. I split my exposures. Again, when I'm sitting with any of my restaurant clients, I sort of see it in two ways. You have your back of the house and front of the house employees, which are your hourly workers. Because there's an enormous amount of turnover usually in that, what I harp on with my clients is to make sure you have that documentation. Have that documentation. Did they sign the handbook? Is the handbook in compliance? Did you have the proper application? Is the sexual harassment thing, is it all signed? Because within 2 years, usually half of them are gone, but they can come back to you years later, and if you don't have that documentation, it's very difficult to do that. Then I look at your management, executive, and owners, and when I document training, and family and spouses are included in that. A lot of my claims involve family coming on the premises and doing things because their dad, son, sister, the wife comes on and she's doing things. It's very important that they're included because they can create serious issues in your restaurant, and they have, and it's been very difficult sometimes telling, hey, Don, don't come in and you can't tell the employees what to do in these instances. So your spouse and family have to be involved because it can cost you hundreds and hundreds of thousands of dollars and numerous amounts of time getting documentation and discovery and everything else. And of course, purchase the proper insurance. That's always a good thing. EPL, general conditions limit. I'm not trying to go too deep. EPL insurance is a little different in that you have to be aware that the defense costs of your attorney lower your limit. Most insurance policies don't do that. So when you're selecting a limit, you have to account for generally your claim is going to be at least 50 to 60% attorney's fees, and that lowers your limit. So it's very expensive to go through some of these things. So when you're selecting a limit, remember that other insurance policies, they're unlimited, and EPL, it reduces it. EPL policies are claims made. Your policy has to be alive and in force for you to make a claim. If you stop that policy and let it expire, it's done. Unless you do some extended, buy some other things. You cannot put in a claim a year later. It's over with. You're on your own. Switching from one EPL insurance company to Travelers, to Farmers, whatever, it's a complex transaction because you have to have extension of deadlines and retroactive dates that you have to work out with your agent. So when you're changing insurance, make sure that you work with your agent to do the proper extensions and deadlines, or else you could be left holding the bag and there's no coverage. EPL insurance can normally be bought in limits of $300,000, $500,000, $1 million, $2 million, and that's about it. Over $2 million, you have to get into some complex groupings and whatnot, because we have clients that have 15, 20 million, but it's much harder. It's hard to get the higher limits, and you have to sort of group LLCs together and ownership, and it gets a little bit more complex. But generally speaking, most of our clients, most of our policies are 500,000 or $1 million. Generally speaking, out of the 25,000 restaurants that we cover. Important policy terms and cost-based. EPL policies, the application that you sign is a warranty. So you better make darn sure you hit those questions correct, because when you have that big claim, that plaintiff attorney is going to blow that application up and make it 24 feet in front of that courtroom, and they're going to say, Michelle, did you answer this square yes? And it's actually no. And it's going to be heard. It's a warranty application, and if you don't answer those questions accurately, it could void coverage, and it's part of the policy, where other auto insurance and other things, it's not part of the policy, so it's a warranty application. Be sure your policy includes these 3 endorsements. Third party, again, that third party is for any other person, wording any other person. So if any other person comes in and harasses, discriminates, says jokes, or whatever it is, and your employee feels that their civil rights are violated, you have coverage. And probably 25% of our claims are from the beer guy, delivery guy, and the plumber, and the electrician. So you must have that coverage. It's worth it. It's a few more dollars, but it's worth it. Raise your deductible on your property insurance and buy it. Wage and hour, you can get only defense for that, but obviously we're seeing an increase in wage and hour. We went through that, the French Quarter place that had a significant wage and hour loss, and we're seeing an increase. God knows, certainly don't go to California, but it's out of control out there. And the immigration extension. So if you have people who aren't properly documented, the insurance will pay up to $50,000 to $100,000 to defend you for the violation of that. Named insured includes, again, spouses and family members. I can't harp on that more. We have so many spouses and family members who are truly maybe even not employees that create losses for the restaurant. Clause for defense counsel selection. I highly recommend that your local attorneys, whoever, like Steve or Michelle, are usually better well-versed in the courts and what's going on in New Orleans versus we had a large claim here in New Orleans and we had some attorney out in New York, and it did not work out. Boy, it did not work out. So there's a clause in the policy if you tell your agent, I just want to make sure I can select my own defense counsel, they'll be usually approved by your insurer. And then the definition of defense costs, it needs to be reviewed, especially if you're a larger restaurant, because the defense costs lower the limit. There's a clause in there that says how the defense costs are calculated, and sometimes you get screwed because guess what? Insurers are sometimes not the most scrupulous people you want to deal with. So watch out for those defense costs. Cost of policy is based on full-time and part-time workers. Again, these policies start out from the most minimal cost, probably $1,700 a year for $300,000, and of course they can get up to tens of thousands with thousands. We have people with 2,000 to 3,000 employees. Full-time, part-time workers, make sure you include your interns and least. Make sure that it's a duty to defend. That's important versus indemnification. That means the insurance company has to defend you no matter what, while they're doing discovery, while they're researching it, while you're getting all this documentation together. Their attorneys have to be on staff defending you versus indemnification language that says you're going to pay the money first and the insurance company is going to reimburse you. Yeah, that's a great deal.
John,
Yeah,
I hate to stop you,
yeah.
but to keep us on schedule.
Okay, these are the insurance companies. Right here, you can pick this up. And this is a great chart for all the 800 numbers and what that you can get from the insurance companies. Thank you very much.
So all of John's presentation is on the back table. Postlethwaite Netterville has information, as does Fisher and Phillips on the back. I say Fisher and Phillips still. It's Fisher Phillips on the back table, as well as some information from the LRA about the different things that we offer. But if you have any questions right now, if Helene and Michelle and Steve and John, for John, you can go ahead and ask them. We have videoed this for future viewing by you and your other employees, and we will send you the PowerPoint presentation. So does anybody have any questions? Yes, we will email. Yep.
Oh.
Anybody got any questions? Yes, sir.
Wait, we're being directed. Wait, this good?
Hi. I have a tip pool bar environment, and my question is, if my trainers are paid a higher hourly rate than everyone else in the bar, is there a legal concern there?
Say that again. You have trainers,
Yeah.
and
Bar trainer and service trainers get a higher hourly rate than the rest of staff.
okay.
Is there a concern that they're on the same level of tip pool with everyone else?
Well, go ahead.
Yeah, I would just say, as long as they're, we can look at those trainers and say they're not supervisory or management personnel, as long as they're employees, yes, that's fine. You can pay them a higher rate, and you're not going to have an issue with your tip pool in that regard.
Is my mic still live? My mic? Yes, sir.
There's lots of issues about 50 employees or more. If I have 65 employees, operate a hotel and a restaurant under the same business, if I was to subsell that restaurant or lease it, would I be now with 20 motel employees and 40 restaurant employees, would I be two separate employers? If I sell the business out completely to someone else.
Are you managing the
Manage everything.
You're still managing everything?
Yes.
Do you have people that go that
But,
are
you know,
shared employees?
From
that,
all these issues, it seems that you're a lot better off. You got less than 50 employees.
Well, particularly with the FMLA.
only for
insurance.
FMLA. I mean, that's only for FMLA. Even if someone, you're still covered under the ADA if you have 15 employees, and if somebody had a disability that required them to have a period of absence for reasonable accommodation, you would still have to do it. So it's, once you hit 50, FMLA is your additional obligation, but you're still on the hook for all these other laws.
It doesn't eliminate all civil
Yeah,
rights.
it doesn't, yeah.
Everything else still
Affordable
applies.
Care
Yeah.
Act, that's
So-
a whole different animal. With
Yeah.
But I would have to know more. I would have to know more in order to know whether you would have to aggregate
Aggregate.
those employees.
Right.
Good thought, though.
But there's a few things that, as I was sitting here, while we wait to see if there's any more questions, a few things that I wrote down to remember to say. Two of them piggyback on this last presentation. Again, if you have counsel that you're using or you want to use Fisher and Phillips, you've got to make sure they're either on the panel for the insurer or you can write them in, because it is really unfortunate when we have worked with a business to tee up a situation and an EEOC charge comes in, they go, nope, sorry, you didn't pick Fisher Phillips when you signed your policy for EPL, and now it's got to go down the street to someone else who doesn't know you, doesn't know your business, and doesn't know the facts of the claim. And a lot of times you end up paying twice because you've already paid your regular lawyers to help you, and now you got to pay somebody else to learn everything all over again. The other thing is the wage and hour rider. A lot of these policies do expressly exclude it unless you get it included, and you are more likely to be sued for wage and hour claims than you are, in my experience, than the harassment discrimination right now, because the wage and hour is so easy. It's like you either paid the person right or you didn't. You either have the documents to back it up or you don't. And these cases are so easy for the plaintiff's lawyers because they know they're going to get their fees. If they get 1 penny for their client, they're going to get their fees. They're almost always pled as a collective action, so it's not one server that's suing you. It's a collection of servers that are going to sue you for the last 3 years.
And they'll make you go back years.
And you go back 3 years is the maximum on a federal claim.
Every check you paid.
And it's in those cases are always more expensive to litigate than they are to settle, or that they end up costing you in the end. And even if all you have is a $100,000 cost of defense policy and you had to pay a $10,000 retention, it is worth its weight in gold, because I'm telling you, you will spend that kind of money. So make sure your EPL has that wage and hour rider. A couple other things you need to know under the new tax law: sexual harassment settlements with a confidentiality provision can no longer be written off on your taxes. So that was a little known thing that sort of slid under the radar. And other things that were brought up in the last presentation about the ADA compliance. So this is your Title III compliance, meaning, do you have compliant bathrooms? Do you have ramping and parking spots? I handle a lot of those cases here for restaurant owners. And again, they are super easy. They don't have to go to the EEOC first. They don't even have to really be a customer. They can literally roll by your restaurant. They can go in to use your bathroom, and then before you know it, you've got a lawsuit from a lawyer. They haven't even told you there was a problem. And the thing that's attractive about these lawsuits is that there's no money to the plaintiff because they're not injured. The money goes to the plaintiff's lawyers. That's what this is about, their attorney's fees and costs. And so typically it's something simple like your light switch was too high, your mirror was too high, you don't have your sink, your pipes wrapped under your sink, you have knobs on your doors and your faucets instead of the levered handles. It's things that are easy to fix, and restaurants and businesses are being sued all over the state. There are a couple of real common cast of characters. They don't like to see my name on the other side because they know who I am. But we do handle these cases, and so that's another thing that we can help you get in compliance with.
One thing,
I'm sorry,
Michelle. One thing I wanted to mention too, someone did mention to me, remember last year there was a lot of noise being made about the overtime rule change and what constituted that threshold before overtime would kick in for certain employees. We know that was put on hold. It's not dead. It's going to come back at some point. But making sure that you understand what your compensation structure is for those people you consider exempt from overtime is a real thing that takes some digging around and making sure you've got all your ducks in a row and the job duties in place and the salary policy. So don't forget about that, because it could come back and your general managers and those supervisory roles are going to be impacted by that. So don't forget about that little
And
fact.
that's something that the LRA, I don't know if you remember when that was hot last fall, that was something that we were sending out constant information on and waiting for I think it was in December, we were supposed to get the
November.
We were supposed to get the final
ruling.
And that got delayed.
So here's the status on that right now. So the comment period closed in September of 17. They are now projecting that we will not have anything on that until October of 18.
And what are you guessing? I'm guessing that the minimum salary level is going to $33,000.
Well, Acosta said during his appointment hearings he thought somewhere in the $30,000 range, so somewhere in between the $455 and the $913 a week. But here's the bottom line. It doesn't matter what you're paying these people. If you have them improperly classified as exempt from under the job duties test, it doesn't matter whether you're paying them the right salary, because just because you pay someone's salary does not mean they're exempt from overtime. And I do a lot of advice with collegiate sororities on paying employees and whether they're exempt or not exempt. And this is a common issue where just because someone has the same job title as somebody else doesn't mean they're doing the same thing, doesn't mean they're going to meet the test for exemption. So from the pay perspective, yes, we need to know what they're going to set that pay at. And there's still a debate whether or not the Department of Labor has the right to even set the pay, because that is still being litigated. But assuming that they can set the pay, we don't need to wait for that to happen. We can be getting our ducks in a row right now and making sure that our people who are classified as exempt are proper, because there are lots of suits around the country with assistant managers. Assistant managers are typically not going to be exempt, but lots of restaurants and businesses have them classified improperly as exempt.
Yeah, let me put it differently. So my client calls and says, a little bit differently, says, Steve, well, I don't have to pay this person overtime because I pay him a salary. I'm like, well, that's good, you pay them a salary, but what are their duties? What are they doing? And so they go, well, what are you talking about? And we find out that they don't meet one of the duties tests. The common ones are executive, administrative, professional, and there's some others. for exemptions. So just, again, don't take out of this that just because you're paying someone a salary that you don't have to pay them overtime.
There's 3 parts to that test. The
Yeah.
salary
Yeah, multiple
piece is
parts,
one
yeah.
piece.
Yeah, the
That's
salary is
never
just the one
changed.
piece. Now, it's not to say that if you wanted to pay someone who isn't technically exempt a salary, there is a way to do it, but we still have to track their time, and we still have to pay them the overtime, the halftime. And I've worked with restaurants to do that. There's all different ways we can structure pay. It's just, we gotta know what you need, and we can help you do it, so.
Any other questions? All right. Hearing
Thanks,
none.
everyone.
Thank you so much.
Thanks so much.